Really good. We got some good tea for you today for the legal tea. Are y'all ready? There's a supermodel. Her name is Gigi Hadid. I might be pronouncing that incorrect, but Hadid. She's a supermodel. She's 23 years old. She's being sued for posting a picture of herself on Instagram. Can anybody give me any ideas why? I'll tell you why. Copyright infringement. I posted this story on the Legal Tea's Facebook page, and I got the angry faces and people like, how can they do that? It's a picture of her. How can they sue her for posting a picture of herself? That's why this conversation is so important. We're going to talk about copyrights today, right? Here's what you need to know about copyrights. Copyrights protect original work that in a fixed, tangible form. She's under contract. Oh, that was a good guess. Nope, not under contract. So copyrights protect work that are in a fixed, tangible form. So in this case, we're talking about photographs. And the internet makes it so easy to forget that photographs and pictures are protected by copyrights, because you can just like right click it and next thing you know it's downloaded to your computer, right? But no, that work is protected. And the person that takes the picture is the person that owns it. So in this case, paparazzi took the picture. She was wearing something? No, paparazzi took the picture of her, right? And because they took the picture of her, they own what happens to that picture. Paparazzi likes to take it and sell it to the highest bidder. Because it's their property, they can do that to an extent. So this is where it gets kind of fishy. This is where it gets kind of we are not them. So if it was just you and I, no one can take a picture of just me and you, because we're not famous, and sell it without our permission. So typically the law says right to publicity. People have the right to say how their likeness is used, make money off their likeness, this, that, and the other. But when it comes to celebrities, what happens in their day-to-day life has been considered newsworthy or news. And because it's news, it's not protected by that same right of publicity law. So because it's news, the paparazzi is able to take this image and sell it without Gigi's consent. But because he took the picture, he's able to say who can and who can't do something with this picture. So even though she is the subject of the picture, it's not hers to do what she wants to with. Isn't that terrible? But this is not her first lawsuit for this. This is her second lawsuit for this. This is the second time she's been sued for this. And the first time she settled it right before they got into it. So the lawsuit was filed and then they settled it. But that's one of the things that I really want to talk about with you all, because as business owners, we have to understand copyright laws. We have to understand what our limits are and what we can and cannot do. So one of the things that we had to take away from this story is who owns the copyright. Who owns it? So her picture is it's her image in the picture, right? Her likeness in the picture, but he took the photograph. The question is, what if she paid for the photo? If she paid for the photo, great question. So if she paid for the photo, and let's think about back to our portrait innovation days, glamour shot days, when we go in there. Anybody got glamour shots? Like I had glamour shots. I don't know where they are. They were a hot mess, I can tell you, right? But you would go in the glamour shop, you'd get dressed up in your boa and stuff, and do all that. And at the end of it, depending on what package you are, depends on what you can do with it. You can buy one or two poses, or you could buy these one or two poses, and these were your photos, right? Or you can buy the big package and they give you a CD and they say, hey, they're yours, you do what you want to do with them. So with those pictures, you remember glamour shots? So with those pictures though, you can get a license. So oftentimes what these paparazzi pictures people will do is they would get a license. They would license out the picture, saying, hey, you can use this picture, you can give me this money, you can use this picture, and you can put it on your magazine cover. It's not exclusive, so I can take the same picture and I can sell it to somebody else. And if you want it to be exclusive, then you pay me more money. And if you want to own all the copyrights to it, then you pay me even more money. So that's how that works. So even if you pay for it, just because you pay for it doesn't automatically mean that it's yours. And that's one of the points that I want to bring up, because you have it's not yours unless they tell you it's yours. So we can even take it one step further and apply it to us as business owners, because today, technology makes it so easy for us to scale our businesses by outsourcing. And so we're hiring different people to do work for us. We're hiring someone to create content for us. We're hiring someone to ghostwrite our book. We're hiring someone to design our logo, right? And as they're doing all this work, they're not employees, they're independent contractors. And because they're not employees, the work that they're creating doesn't belong to you or your business. They create the work, they own the rights to it. And if you want to own the rights to it, then your written agreement needs to assign all that work, all those rights to you. So I have an independent contractor agreement and a virtual assistant agreement that says that all the work that's created belongs to me. Because it does. It does. I want all the work that's created to belong to me. So I need you to assign those rights to me. So that's what we want to, that's another takeaway that we want to take up. So the first takeaway that we want to get out of this whole situation is the person that creates the work, the one that brings it to life, is the person that owns it. They're the person that says what can and can't happen to it. That's very, very important, which brings us to point number 2. Because they are the person that says what can and cannot happen to it, that means you need to have a written agreement. Just because you pay for something doesn't mean that it's automatically yours. That's not, I always refer back to when you go on a date. You go on a date with someone and they're paying for your meal and stuff. That doesn't mean that they have a right to expect anything else from you if you haven't agreed to it. The question is, that's before it's done. Yes, do it before. Have the conversation before the work is done. You want to have this understanding before the work is done, because you don't want them to hit you with something like, I have a client who has different tiers of pricing based off of what type of license you want. So if you just want a logo done right, and you just want to use it for business promotional purposes, you can buy this logo for a certain price, but the license is limited to, you can put it on your business cards, your banners and things of that nature, but you cannot use it for commercial purposes. As soon as you take that logo and start putting it on something and selling it, then you have a problem with them. That requires a different license. So you want to have that conversation up front so you know what you're paying for and what you're getting. And you want to have it in writing. What you don't want to happen is, you have this understanding and they give it to you and then you blow up. Then all of a sudden they're coming back to you talking about, oh, I need some more money, or no, you can't use it for that. All right, who beans? So that was thing number. So out of this Gigi Hadid lesson, we learned that the person that brings the work to life is the person that owns the copyright to it, unless they are an employee doing the work in the scope of their employment. And so so when I say that, an employee doing the work in the scope of their employment, what that means is I always give the same example. Let's say I work at McDonald's, right? And my job is doing fries. And I create a logo. I'm just drawing a logo. I own that logo for McDonald's. McDonald's doesn't, because my job is frying fries, not drawing logos. Now, let's say I worked in the corporate office and my job was in the graphic design or marketing department and my job was to create logos, right? Then the logo I draw does belong to McDonald's. See the difference? So one of them, I'm doing the job in the scope of my employment, and the other one, I'm not doing it in the scope of my employment. So even when it comes to employer situations, you have to be aware of whether or not the work they're doing is in the scope of their employment, as far as ownership is concerned. And then they have some other things that work for hire. For typically the business owners, it doesn't really apply. Such a great conversation. But didn't I tell you, these things are so interesting. Who would have thought that somebody can get sued for posting a picture of themselves, right? You're like, what? How does that happen? So the second thing is, just because you pay for it doesn't make it yours. You want to make sure that they assign those rights to you. And the third thing I want to say is very important. So we talked about the paparazzi and how they're able to take pictures of celebrities without their consent, because the laws are, basically they don't give celebrities and public figures the same privacy that they give normal people, right? But this is what I want to tell you. This is the caveat to that. Just because the paparazzi can do it does not mean that now you can take a celebrity's likeness and start promoting your goods or services using their likeness. Don't put them in a t-shirt talking about queens are born in May. You know, so my birthday's in May and people are already marketing to me, right? And I'm seeing pictures of like Rihanna and Oprah and all these talking about queens are born in May. No, don't do that, because now you have a whole nother issue. Now you don't just have a right of publicity issue, you have a truthfulness in advertising issue. Like, does the celebrity really endorse this product? No, will they really be in the club? You know, the club flyers love to have artists and different things in their flyer. Will these artists really be at the club if I show up? Now you got a truthfulness in advertising issue, and that's the feds monitor that. So don't do that. You're not the paparazzi, right? So you cannot use their likeness to promote your stuff. All right. So those are our 3 top takeaways for today. On the other end, you can be sued by the person that thought the celebrity will be there in the club. Like, yes, I just came here because I saw Beyonce was on the flyer, so I thought she was going to be here. That's why I paid the cover price. So, you got to be careful. You have to be careful. But I sure do appreciate y'all hanging out with me today.